Hey folks, this is Attorney Sharif Silmi. Today I'm going to actually be addressing some of the most recent developments that concern those of you who have lived through what has now been a decades-long immigration backlog, particularly for folks from who are born in India. The way the U.S. Immigration system works, particularly within the employment-based categories, is that your immigration priority is based on what's called chargeability. And chargeability is determined by country of birth. So if one is born in a particular country, they are subject to a cap limit on the number of visas that are issued for individuals from that country. And presently, it is that the cap is 7.5%. So of all the visas that exist, of all the opportunity to apply for immigration based on an employment-based category, one particular country may only take up 7.5% of the total visas available. And because there are a very high number of skilled workers who hail from India in particular, and of course, and also China, you have wait times, you have backlogs in the employment-based categories. What I want to do is talk a little bit about whether the proposed legislation is going to solve that, and what that means for you and your family, for those of you who are in this immigration backlog. As many of you probably know by now, Zoe Lofgren, the Congresswoman from California, along with a Republican colleague of hers, John Curtis, introduced what's called the EAGLE Act, okay? The EAGLE Act has now been introduced to Congress. This is the second year in a row, and it's been introduced, multiple years, where they have similar legislation to get rid of country caps. Before we talk about what this legislation does, I want folks to really understand how the system works. So within the US, there are two bodies, legislative bodies. One is the House of Representatives, and the other is the Senate. So for a proposed bill to become law, it must pass both bodies. And if you've been paying a lot of attention to this situation, the preceding bill, the bill from last year, was actually passed by both the House and the Senate, but it did not become law, right? And there's a very important reason for that. And I'll get into that. So for example, last year, the bill to remove country caps was passed by a huge majority in the House. It was more than a 3-to-1 ratio of those who supported the legislation. And it was also, a similar bill was passed in the Senate. However, the bill that was passed in the Senate did not match the exact bill that was passed in the House. So what happens is it goes to what's called a reconciliation committee. And then the reconciliation committee must come to some understanding regarding, what the bill ought to look like. And then it must be voted again by both bodies. And the process basically died before the Congress's term ended, and it was a failed mission. So what we want to know is what is going to happen this time, or what is the likelihood of this bill passing now. So again, we have probably huge support within the House for the legislation. The idea that country caps on immigration, per country cap, is a good thing, either from an economic perspective or even from just a moral perspective, I think is widely accepted as being rejected. I mean, folks understand now that we cannot continue to have these country caps. So the question is, will it be resolved? One thing that there is always bipartisan agreement on is that immigration bills are really, really hard to pass. And that's, the unfortunate reality. So what we're looking at now is that it must pass the House of Representatives, and then the same bill must be taken by the Senate. Now, if you look at the Senate right now, it is a 50-50 split between Democrats and Republicans. Therefore, in order for any bill to pass, it must receive support from all 50. For example, likely in this scenario, we would need all 50 Democratic senators and additionally 10 Republican senators. So while this is exciting news that, again, the EAGLE Act, as it is called, the elimination of country quota is being introduced, until you can find 10 Republican senators willing to go on the record and support the bill in the same form as is being introduced and, within the House, it is a little bit premature to depend on this legislation to advance our cause. And I think that, it's important. I'm going to go into some of the highlights of the EAGLE Act, but we need to really understand and be realistic about the situation from the perspective of, whether or not it will actually pass and what kind of timeline will it mean for you and your family. So, just a couple of things on what the EAGLE Act actually does. In particular, for those who are from countries with an enormous backlog, the thing that we have to understand is that 75% of the current employment-based immigration backlog is made up of individuals who hail from India. So that is an enormous number. And backlogged Indian workers face, an impossible wait time right now, particularly if you are now, if your priority date, so your priority date is the date that you are, you have submitted your employment-based immigration petition. So if that priority date is in the last, year or so, the equation works out such that it is pretty much impossible under current law for you to acquire permanent residence, an actual green card within your lifetime. That's how sad the situation has, gotten. So what we're looking at with the EAGLE Act is that the per country cap would be largely removed, and you would have the highest number of applicants being from India and China. They would receive the maximum under the law for the first 3 years of 30% of all of the employment-based petitions. So, it would really, I think, take care of a very, very large swath of individuals who are in the backlog. So the provisions of the EAGLE Act are absolutely consistent with the predecessor bill, which was the High Skilled Immigrations Act. And we are, certainly going to see a huge benefit if it actually passes, but that is going to take an enormous undertaking and effort from folks, within Congress to, reconcile the different aspects. And one thing that I'm really, really concerned about right now is the rising level of anti-China sentiment within the government. And this would actually be a potential poison pill for the that may be introduced into the legislation, where some of the more nationalist type of Republican senators will want to add an amendment to what is now a pretty good bill in the EAGLE Act that would then be rejected by Democratic House representatives. This is something that is of huge concern. So, whether or not this bill actually becomes law will largely depend on the ability of lawmakers to craft it in such a way that would avoid the more controversial types of initiatives that were placed into the bill last time around, and that caused the fairness for employment-based petitions to be rejected or delayed so long that it eventually expired. So, that is what we're really looking at. Then you have to also consider the implementation of such a bill, because it would not be implemented immediately. So if, for example, it passes this year, then you are still looking at probably a 2-year process for the bill to be implemented to the degree that you're actually going to see practical benefits for you and your family. And this is, again, one reason why we still have to look at other options. One bill that has actually passed the Senate today, in fact, June 9th, is a bill to encourage tech competition. So there is a bill that passed where they're going to invest $250 billion into certain industries that they deem to be of national security concern as it relates to competition from China. And this is actually giving me a little bit of concern that the attention being paid to the technological aspects of competition from China will bleed into the country quota process as it relates to those of you who are, most of our listeners probably from India. So I think that we are hopeful, but we were also hopeful last year. And there were, enormous hurdles that were put up. So you have to be vigilant in the sense that, you may or may not see relief come through this legislation. So, while it is somewhat encouraging that, the House is introducing the bill relatively early in the term, it still has a long march before it becomes a law. There will be support from the administration for the bill. Definitely Kamala Harris, the vice president, has been a long time advocate for removal of country quota. Obviously, she has kind of familial ties with India and is very cognizant, very aware of the struggle of, and plight of the employment-based immigrants who are, living in the U.S. and not able to adjust status because of the country quota. So, you're going to see huge push from the administration. But again, it's all going to come down to whether we can get the support of 10 Republican senators without them crafting some kind of carve out for China. Because as soon as they craft out some carve out or some, sort of restriction on Chinese immigration, you are going to have a huge pushback from the House, because this has a historical precedence in the United States. You have to understand this, that there used to be a law in the US called the China Exclusion Act, the Chinese Exclusionary Act. And this was a racist law that existed in the beginning of the 20th century. And nowadays it's seen as a historical mistake and discrimination that existed. So there's a lot of sensitivity to, among Asian Americans, particularly Chinese Americans, toward any sort of restriction on folks from China. So if, for example, they've introduced things like if someone had worked in a state-controlled company. Well, within China, almost every company can be argued that it's state-controlled. So that may have the effect of excluding lots of otherwise qualified individuals. So, unfortunately, the number of, people, even though it's 75% of the people on the backlog from India, it's actually not going to be, there's no disagreement among the legislatures, among the House members and senators, the administration, that the India backlog situation must be solved. All of them agree on it. The problem that we have is that every time we move towards solving the problem, there's an issue that you cannot separate the Chinese issue from it. And that becomes sort of a poison pill for the legislation and causes a lot of problems for us in terms of, you know, how we are able to move this legislation along. That is why, you know, we always have to be cognizant of an all of the above approach. That means that if you are presently in a situation where you have an existing approved EB3 or EB2 employment sponsored green card petition, right? You have an existing approved I-140, you need to make sure that you are hedging your bets in a way. If you're depending solely on your employer, then, you know, that may be a risk factor. So where, for example, you know, if you're laid off or if you, you know, lose your status in any way, you would not be able to adjust status at that point. And those of you who have maybe downgraded to EB3 where the dates have advanced, it is also important for you to consider filing or thinking about an EB2 category, for example, national interest waiver, because that will allow you to have kind of both areas of the employment-based categories met, so that if there is advancement in the law and that people are able to make sure that you are put yourself in the best position. So we are, you know, definitely hopeful. And while we are hopeful, we need to make sure that you are taking care of your interest. So that interest being, if you've changed jobs, if you've done for example, you're on an H-1B, you have a previously approved I-140. So you have an older priority date, and now you've changed employers, and the new employer has not yet filed your perm application. One thing that you may want to do is file a national interest waiver under EB2. You'll be really surprised how many highly skilled workers, particularly in the IT related fields, will qualify for that national interest waiver. So I'm looking at the question, if someone has an approved I-140 from an employer, should they wait for the legislation? So that is actually a really good question, because if you're waiting for the legislation and you have an approved I-140, you need to ask yourself, is my job circumstance very, very stable? If it is, then that may be an opportunity where, you know, you can potentially wait. But I would argue that you need to take an all of the above approach and take matters into your own hands. And that may be looking at the potential of filing in an EB1 category of extraordinary ability, or self-petition under the EB2 category of national interest waiver, where you have, for example, an EB3, then and under that circumstance, you'll have an EB3 track employment-based I-140. You'll also have an EB2 track I-140 under national interest waiver, and potentially you can have an EB1 track I-140 for an individual of extraordinary ability. So there are ways that you can take matters into your own hands and not just be, you know, dependent on what may or may not happen with respect to the legislation. So, you know, looking at the different aspects of what choices you have and what sorts of, you know, things that may impact your case, the most important thing to understand is you are not without options, right? In my view, if you are in the US, if you're working in a highly skilled position, you're making over $150,000, $200,000 per year, and the solution that you have is let me sit on my hands and wait and see what happens with the legislation, then I would say you're doing yourself and your family a disservice, because there are other options available to you. Like I mentioned, National Interest Waiver EB2, or you can see whether you qualify for an EB1A. And those of you who may be new or not, heard any of my previous presentation, you might think, well, I cannot qualify for an EB1A because, I don't have publications, I'm not a scholar. That is absolutely not the case. That is a falsehood that has existed for a long time. And we have proven that you can qualify for EB1A based on having a high salary, based on having business-related contributions of major significance. I would underline business-related contribution. So when you think about a business-related contribution, that could be a technology-related contribution. And it is actually, in my view, more persuasive to have a business-related contribution than it would be to have a scholarly-related contribution, because a business-related contribution is one that would make an impact on jobs and economy and things like that. That is where we look at the provision within the law, which says, are you going to prospectively benefit the United States? If you can demonstrate to the government that you will prospectively benefit, that you're going to bring about future benefit to the US, this is an important indication that you will be approved for a first category EB1 petition. And under the current situation, the EB1 first category employment-based immigration category is current for both India and China. So if we are, concerned that this is going to be another bill that somebody throws a poison pill in it, or it's not going to pass, then certainly we should be looking at EB1. If the bill does pass and you are in a situation where, you might have, let's say, a priority date of 2017, 2018, you probably are still looking at, 2 or 3 more years before you're going to be able to adjust status, depending on the final outcome of the bill. There are some hopeful provisions in there that would allow someone to file the adjustment of status based on having an existing approved I-140, but is not very clear that it will actually result in the issuance of a green card. So if you think back to the end of 2020, in October, that's when the new fiscal year went into effect, there was a huge advancement in the EB3 category. And when that huge advancement took place, many people, even, over, I think, 100,000 people became eligible to file their adjustment of status. We are now in June of 2021. It is very, very few of those individuals who filed their adjustment of status based on the filing date becoming current for them in the EB3 category, or based on them downgrading to the EB3 category and filing an adjustment of status. Very, very few. I am yet to meet one. So I don't want to say there are none, but I'm yet to meet one who actually has received a green card. They've received an EAD card, but they have not received a green card. And, so if you get that EAD card while you have a pending I-45 based on a third category employment-based petition, you need to be careful how you use that EAD card and whether your adjustment of status, if it's going to be in perpetual limbo, may be impacted by your changing of jobs or companies and the like. So, there are a lot of risks there still, even with the legislation and your ability to file your I-485. So again, we are being very diligent, looking at all aspects of the law and its implication for you, particularly folks, the 75% of backlogged employment-based workers, those who hail from India. And I would say, regardless of whether you are optimistic or not, you really need to take matters into your own hands. I've met so many people over the years who have children, and those children are aging out, meaning that they're reaching age 21 or becoming close to reaching age 21. They want to go to college, but they are essentially not able to adjust status because they are in this backlog, country quoted discriminatory backlog. So, without this legislation, we are going to continue to have that suffering unless you do, as many thousands of folks, have done, and we have done on behalf of folks, take matters into your own hands. Look at what your options are. Can we think of a narrative in which you will qualify for EB-1? Can we look at a national interest waiver? Will it be beneficial for you to have an approved I-140 in multiple categories? Those are the questions you need to be asking, and you need to be very strategic about how you approach these situations. If you are thinking about a job change, an H-1B transfer. So now we know that H-1B transfers are happening with less RFEs from the government. But one thing we need to do is make sure that you are transferring your H-1B to an employer who will immediately work toward refiling your perm I-140, because if this legislation goes through, or if just there's natural advancement in the visa bulletins and your date becomes such that you're able to file your adjustment of status, and you have transferred from one employer to another, the new employer, if they're dragging their feet with filing your I-140, that could be a huge concern and problem for you. So it might be in your interest, if you've done an H-1B transfer recently, to consider a national interest waiver. And for a national interest waiver, you do not need publications. You do not need a master's degree. You may qualify with a bachelor's degree, 10 years of experience, membership in a professional organization, certification that you are a license to work in a particular profession, and also that you work in an area that is of national benefit to the US, that you are well positioned to advance that particular area of endeavor. So there are a really wide array of folks who will qualify for the national interest waiver. And I would say that anybody that has completed a transfer to a new employer, and that employer has not yet commenced the perm I-140, or even if they have and you want to have a backup, a national interest waiver is a great way to sort of hedge your bets in a way and protect the interests of you and your family. There's a question here. I just want to address it before we conclude regarding extension due to COVID. So there is a great flexibility right now when it comes to extending status based on COVID concern. And so, Mian, that could be something that you're able to take advantage of. It depends on what your current status is and what status you're seeking. But if, for example, you're visiting the US and there's an enormous outbreak in your home country and you're afraid of departing and traveling as a result, then we can file for your extension. So I would ask if you could call our office, 443-329-2929, or email us at info@silmilaw.com. We can definitely help you make sure that your extension is filed and that you remain in good status. Now, if your status, like if you enter the country as a visitor and you remained for more than 6 months, then that could be an issue and you need to request flexibility. And here, if you've already done one extension, and so one thing I could tell you is that USCIS has very limited resources, and they are not successfully or adequately handling the number of extension requests that are being filed. So for example, if you file for an extension, the extension period you're requesting is for 6 months. It will actually take more than 6 months for you to receive a response to that request for the extension. So before your initial 6-month period expires, you need to file a subsequent extension request for an additional 6 months. If you fail to do that, don't worry, just contact our office. We will find a way for you and request flexibility be rendered on your behalf. So I just wanted to check in with everybody and let them know that we are watching this legislation very carefully. We are supporting the legislation that exists to remove the discriminatory country caps. And we are at the same time letting you know that you need to do everything to protect you and your family. That is why I encourage you to undertake an all of the above approach. Every immigration benefit that you qualify for, you may apply for. There is no contradiction between having an employment-based perm application and having self-petition under national interest waiver or EB-1A, for example, among other immigration benefits that you may qualify for. And you can reach out for a consultation. So I thank you for watching the video and look forward to your comments and questions. And we're always here to help guide you through this process and hope everybody remains well.